The president needs to tell Nigerians the kind of pardon he has granted to the former governor of Bayelsa State and the 7 others. This is the view of Mr. Femi Falana, a senior advocate of Nigeria. He'll join me shortly on the program, but first, here's a recap of some of the top stories from the courts. I'm Shola Sheyeli, and this is Law Weekly on Channels Television. We begin with the report that the Federal High Court sitting in Abuja has voided in its entirety the deregulation policy of the federal government on the downstream oil sector. In a suit filed by a legal practitioner, Mr. Bamidele Aturu, against the federal government, Justice Adamu Bello ordered the government and its agents to stop the deregulation policy forthwith. The court also held that the decision to deregulate the downstream sector of the petroleum industry without fixing the prices at which petroleum products may be sold in Nigeria is unlawful, illegal, null and void. The court ordered the government, especially the Minister of Petroleum, to ensure the fixing of prices of petroleum products as mandatorily required by the Petroleum Act and the Price Control Act, and to also comply with the court verdict by fixing and publishing regularly prices of petroleum products. At the Southern High Court in Johannesburg, Judge Niels Classen, presiding over the trial of Henry Oka, has fixed Tuesday the 26th of March for the sentencing of the former Niger Delta militant leader. An application for a special entry of irregularity or illegality brought last week Monday by Mr. Oka's defense counsel in the terror case was declined by the court. After hours of arguments by the prosecuting and defense counsels, the judge ruled on the 3 major points raised in the application. The court held that it is frivolous and absurd to say that the presence of the State Security Service SSS prosecutor Clifford Osage had an adverse effect on the case. On the 21st of January, Henry Oka was found guilty and convicted on 13 counts of terrorism. The charges relate to 2 car bombs in the Federal Capital Territory, Abuja, in which 12 people were killed and 36 injured on Nigeria's independence anniversary of 1st of October 2010. The case filed by a group of lawyers seeking an order of court to compel the National Judicial Council (NJC) to reinstate the suspended president of the appeal court, Justice Ayo Salami, was last week dismissed by the Federal High Court, Abuja. In a ruling on the preliminary objection filed by the Attorney General of the Federation and President Goodluck Jonathan, Justice Adamu Bello held that the lawyers had not been able to prove to the court how the suspension of Justice Salami was injurious to them. The court further held that based on this lack of local standi, the court also lacked jurisdiction to hear the suits. 7 legal practitioners had filed a suit to seek an order of the court to compel the National Judicial Council to implement the recommendation of its 3-man committee headed by the Chief Justice of Nigeria, Mariam Aloma Mukhtar, that the suspended president of the appeal court, Justice Ayo Salami, be reinstated. In a separate case, reprieve came the way of a former director of the Police Pension Reform Office, Mr. John Yakubu, who is standing trial for false declaration of assets before the Federal High Court, Abuja. His bail application was allowed by the court. Mr. Yakubu, who has been in prison custody since the 30th of January 2013, was granted bail in the sum of 10 million naira with one surety in like sum, who must be a civil servant resident in Abuja. The court also ordered him to surrender his travel documents. Hearing in the case was then adjourned to the 22nd of April 2013. The Federal High Court Lagos has fixed the 28th of March to rule on the interlocutory motion filed by some lawyers seeking to restrain the Nigerian Bar Association from collecting or enforcing the new fees regime. Mr. Tunji Gomez, who argued the application on behalf of the plaintiffs, also urged the court to make an order of mandatory injunction compelling the defendants to continue to collect the fees as it were on the 1st of January 2012. Mr. Gomez also told the court to order the defendants to stop sending out text messages to lawyers, persuading them to pay the new practicing fee until the case is finally determined. Responding to the arguments of the plaintiffs, counsel to the first to 4 defendants, Mr. Okeamechi, senior advocate of Nigeria, urged the court to dismiss the suit as lacking in merit. He argued that the plaintiff's suit had no legal basis and was merely aimed at wasting precious judicial time. The plaintiffs had filed a suit against the defendants, challenging the upward review in the practicing fees for legal practitioners in the country. They described the increment in the practicing fee as far too outrageous and urged the court to restrain the defendants from implementing the new payment scheme.
You see, life has just got easier. You stay connected to Channels TV, where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
channelstv.com. The news at your fingertips.
Welcome back. Now, legal practitioners and indeed quite a number of Nigerians remain divided over whether those granted pardon can have their forfeited assets returned. Here's what some lawyers have to say about the issue.
If they had conceived in their minds to give him back his assets, then, that's when an issue would arise. But if the terms of the pardon is that, look, whatever you have forfeited is good, is deemed forfeited, you're not having that back, then the question will become academic. You understand what I'm saying? So everything depends on how deep the conspiracy between Alamiesiegha and Jonathan in the grant of this pardon is. You understand what I'm saying? But if it now comes to the fore that actually they had conceived that Alamiesiegha should have his properties back, then there are other principles of law, that should make Alamiesiegha forfeit those properties, because any advantage you got for yourself, through public office that you should not have gotten, you are liable to forfeit that advantage, So that is there, and there's also the provision in the EFCC Act that even an acquittal does not necessarily mean that assets seized from you will be returned to you. It all depends on the grounds of the acquittal. You understand what I'm saying? So a pardon per se may not, under the EFCC Act, translate to Alamiesiegha having all his properties back.
Well, a pardon is executive exercise of discretion. It is a mercy hearing. It is not a judicial hearing that results in a quashing of a conviction. So a pardon does not have effect of quashing a conviction. So if somebody is convicted and he goes to court, and the appeal court quashes the conviction and set aside the judgment, that's a different thing. If you say, okay, the person has restored to the position he was before the trial, that means if there's any forfeiture of asset, the person recovers it, for instance. But that is not with pardon. Pardon is executive exercise because it is not done on merit. So what pardon does is to restore the rights lost by virtue of the conviction. It does not quash the conviction for purpose of recovery. Okay, for instance, if the person has been imprisoned, and then pardoned, are you saying that those imprisonments are illegal? No, the period he was in custody is not illegal because he was convicted by the court. So what pardon does is simply to say, well, if convictions say if you are convicted you cannot have certain privileges, we hereby restore those privileges. It does not restore the person's, it does not wipe away the conviction itself. So I do not think that that Alamiesiegha's assets that were forfeited to government, that there is any legal basis for him to ask for their return. There is no such basis. Except government may, with a gazette, restore those properties as a consequence of the pardon. Without such action being taken by government, there's no way he can go to court to reclaim them.
Now to the interview segment. Mr. Femi Falana has been in the news. He's one of those who believe that those granted pardon can make a case for the recovery of their forfeited assets. Beyond that, however, he makes a case for the re-engineering of the Nigerian legal system. Let's start with this peculiar, for want of a better word, peculiar perspective to the presidential pardon granted to former governor of Bayelsa State and 7 others. You cited an appeal court decision and claimed that the government
the former governor can make a case for the return of his forfeited assets. Can you explain that further?
Well, going by the decision of the Court of Appeal in the case of Chief Olufalaye and General Olusegun Obasanjo, once a person has been pardoned, particularly full pardon, is entitled to have all his rights and privileges restored. And that was why the court described any person who is pardoned as a homo novus, a new man completely. In this case, once the pardon, as it were, is a full one, those who have been pardoned are entitled to claim their forfeited assets.
The argument that you made about Alamiesiegha being able to make a case for his forfeited assets, does this also extend to the former managing director of the Bank of the North, Shetima Bulama, and the General Dia and all the other military personnel that were also granted pardon?
Everybody. Once the pardon is unconditional, if it's a full pardon, everybody whose assets were confiscated at one time or the other are entitled to have them returned.
They can also ask for the return of their rank and their entitlements in the military.
And that is why the government has to explain what it has done. Is it full pardon? Is it a conditional pardon? Each of the cases has to be treated separately, because that itself will lead to further problems. Because some of the seized assets, particularly funds, have been spent by the Bayelsa state government. I'm talking of the funds recovered from abroad. Some properties have been sold, and the proceeds have been turned over to the government of Bayelsa State. But I'm not sure Chief DSP Alamiesiegha, I think his own main concern is to have the stigma of infamy removed from his name. But if he insists on claiming his assets, the government may have no choice in the matter, once it's an unconditional pardon.
But then the question that arises is, where is the justice for the people of the Bayelsa State, whose funds it is that we're talking about here? Where's the justice in there for them?
Well, you see, for me, I have looked at that case from another perspective. And for me, you have to situate the pardon granted to Chief DSP Alamiesiegha within the current legal paradigm. Whereas all his colleagues who were charged in 2007 have had their cases totally hanged, or as it were, frustrated. Their trials have been frustrated. 2, one of them has got a permanent injunction. Another one pleaded guilty and was asked to pay a 3 million naira fine. In his own case, he was removed as a governor. He pleaded guilty, he was jailed, convicted and sentenced to 2 years imprisonment. And all his traceable assets were seized. If you think of other situations, and in the cases that are in court, I can assure you, we may never get to the root of justice. And we'll never get justice in those cases. Some have been pursuing interlocutory appeals for 6 years now. In fact, one has just moved to the Supreme Court. That will take the next 4 or 5 years. By the time you come back, the witnesses can no longer be found. The trial judge is likely to have retired or transferred. So you are starting de novo. You are starting afresh. Meanwhile, one person, Senator Joshua Dare, who jumped bail in the United Kingdom, is now in the Senate, making laws for us. So when you look at all the circumstances, you may want to have a pity on the former governor of Bayelsa State. For instance, many have been granted amnesty. Many cases have been withdrawn from court, including the Alamiesiegha's case. It was struck out for want of diligent prosecution by the state that did not want to prosecute the suspects. In many other cases, including murder cases, cases of assassination, this state, the Nigerian state, the Nigerian neo-colonial state, simply does not want to pursue any prosecution. Even in the case of the former Attorney General of the country, Chibolage, who was assassinated, the first judge to whom the case was assigned cried out that he was under tremendous pressure to free all the accused persons. And for that reason, he abandoned the case. Another judge, before whom the case was pending, many of those who have made confessional statements were freed because the state filed a nolle prosequi. Now, we're no longer willing to prosecute them. So, this is the environment under which we operate. You do not have the rule of law. The government is not committed to the eradication of impunity in the country. You therefore may want to discourage anybody, or you may want a man who pleaded guilty to regret his action. If his colleagues are walking free on the street and they have not been stigmatized in any way, in fact, they have taken over from the state and made a mockery of the legal system. And there are quite a number of my colleagues who are prepared to frustrate the criminal trial of any member of the ruling class once the pay is good. And that is what is going on.
I know that these are all weighty issues that you've mentioned. But some people will ask, that where is the justification to keep prosecuting when they might eventually get pardoned?
No, no. For me, I think we are being challenged, particularly lawyers and judges. I think the legal system is being challenged. We are being asked to go back to the drawing table. Why have we allowed the criminal justice system to be hijacked and discredited by a tiny minority of big boys and girls in the country? And that is what has happened. Hence, at a parade last week at Panti police station, some armed robbers were paraded. One of them, one Garba, challenged the media. Why are you embarrassing us? Don't you know in this country, big people like senators and others are criminals, and they're now being prosecuted? Don't you know we have to take care of ourselves? For me, that was a serious challenge by an armed robbery suspect. And once you have a legal system that is skewed, that is manipulated to get the rich out of the legal net, we're in trouble. In other civilized countries, where you have stable democracy, pray you are not caught, because the law is higher than anybody. But here, the contrary, the reverse is the case.
Yes, and you've indicted the lawyers. Some of your colleagues contribute.
No, they deliberately. I mean, there is no apology about that. I say it in the meeting of lawyers, in the meetings of lawyers, and I say it publicly, and I challenge my colleagues.
So what's the way?
And I have warned my colleagues that we are in trouble. If we continue to manipulate the legal system to the extent that people lose total confidence, they've lost a measure of confidence. But if it becomes total, anarchy and chaos will become the order of the day, and we are all going to suffer for it.
Stop this manipulation of the legal system.
The Nigerian people will have to intervene.
How?
In many ways. Cases that are deliberately plotted to fail, like the Alamiesiegha's case. the trial judge warned the state that if you continue to be lackadaisical in the prosecution of this case, I'm going to throw it out. With the benefit of hindsight now, I should perhaps have mobilized my colleagues in the human rights community to storm the court, to storm the office of the Attorney General, and demand to take over the case, since the state was reluctant to prosecute.
So is that option foreclosed?
Well, it's not foreclosed. Okay. The other one, but for the harassment of the state by our colleague, Festus Keyamo, right? Honorable Farouk Lawan would not have been charged, and his colleague would not have been charged. And I think we need more of such actions.
So lawyers,
and this should not be limited to activists. Okay. The Nigerian people must now take the destiny of this country in their hands.
And storm the court.
And well, not necessarily, but sometimes we may have to do that. But there are other measures that can be adopted. Lawyers and judges who deliberately manipulate the law to free those who have committed heinous offenses will have to be exposed and reported to the National Judicial Council. And I'm also happy that has started.
As a way of also preferring solutions, the NBA Ikeja branch has advocated an amendment of the Constitution as a possible solution. Well, what do you think of that?
Well, I haven't discussed that with my colleagues. And I would rather prefer that we leave Section 175 and 2.1 and 2 with respect to states for now. And take the legal system as lawyers, examine it properly, and convince ourselves whether we can continue like this.
I've also heard some people say that in saner climes that this is an abuse of powers by the president, and its basis for moving against him is an impeachable offense.
The government itself did not handle the matter maturely. The government itself was not convinced that what the step it took was right. Hence, number one, after the meeting of the Council of State, the spokesperson, the governor of Adamawa State, Admiral Murtala Nyako, told the whole world that pardon for anybody was not discussed. That itself, if that statement is true, the entire exercise can be successfully challenged. Secondly, when the government eventually admitted that the exercise was carried out, we were told by the Presidential Aide on Public Affairs, Dr. Doyin Okupe, that it was the National Council of State, not the President, that carried out the exercise. Again, that is illegal, because by virtue of Section 175(2) of the Constitution, the President is required to consult with the Council of State in taking the decision. So the decision has to be that of the President. Hence, I came out to say the President should be courageous to admit that he took this decision. Thirdly, some of those who were pardoned, including the two sets of alleged coup plotters, or those who were indicted in the phantom coups of 1995 and 97 to remove the murderous Sani Abacha junta, have been pardoned. Hence, the family of the late General Shehu Yaradua came out to say, we never asked for pardon because our man was pardoned in 1998. So I think the government set out to embarrass itself.
So it is a basis for an impeachable offense?
I'm not quite sure. Because once the president is empowered to exercise the prerogative of mercy without conditions, that is a problem.
That has been our interview and indeed the program this week. I am Shola Shayeli. Thank you for watching and do tune in same time next week.